in the matter of the marriage of Brianna M. Kirkpatrick, now Hilton, and Caleb B. Kirkpatrick, respondent case number 2021 DM 135. Beginning with petitioner, would counsel announce appearances for the record, please?
Good morning, Your Honor. Steve Turley on behalf of the petitioner, Brianna Helton. I appear by Zoom. Brianna is with me at my office. She also appears by Zoom.
Susie Locke on behalf of the respondent, Caleb Kirkpatrick, who appears in my office and via Zoom.
Matter comes before the court at this time upon a motion for attorney fee determination and final judgment filed by Mr. Turley on behalf of his client on January 27 of 2025. Ms. Locke, I received what looks like a Kansas Payment Center history report from you. Mr. Turley, do you have that?
I do.
Okay. Mr. Turley, what relief are you seeking today?
There are two issues before the court, Judge. One, well, before I proceed, do you have my exhibits that I mailed out?
I do.
Okay, great. There are two issues before the court. One is whether interest should be added to the judgment, and the second is whether I should.
Buckle up, guys. Today we are going to dive into a courtroom showdown where money, contempt, and parental disputes collide. The hearing kicks off with all appearances announced, setting the stage for a tense battle over attorney fees and interest. Right from the start, you can feel the stakes, one side pushing for justice, the other arguing timing and fairness. The court establishes the framework, and you know this isn't going to be a quiet proceeding.
My client and I should be awarded attorney's fees, and if so, in what amount? Within the materials that I sent you, Judge, one was Exhibit 5, which is a proposed order. That order is agreed to by counsel, but you'll notice, Judge, that there are some highlighted parts of the document. Those highlighted parts are where we have open questions and need some direction from the court. So we've got the journal entry pretty much worked out once we get a decision from you, Your Honor, on these remaining items.
I notice your creativity in the title, order, Mr. Turley.
What would you have called it, Judge?
Mr. Turley, this court is of a strong belief that each order and journal entry filed in a domestic case should define exactly what's covered by the terms of the order, at least some summary. I only make that comment is that it's difficult when looking through a listing of documents, especially an electronic file, when everything's called order, journal entry, order, journal entry, without definition as to what these orders and journal entries are all about. It just seems that the title should really explain a little bit better. That's not really what is before the court today, Mr. Turley. I do appreciate any drafting efforts that were made prior to today. I see paragraph 6 has question marks, and that's regarding your request for attorney fees.
Yes, the question marks are where we have open questions.
I'm looking at paragraph 7, which is your attempt to do a breakdown of disposition of proceeds.
Yes, Judge. The open questions are the attorney's fees and the additional interest, if any. The other amounts are agreed to.
Why is interest an issue, Ms. Locke?
Your Honor, the additional interest that has been occurred from this date of the sale until the date of this hearing, we don't think should be applicable because the funds have been held in Mr. Turley's account. We also suggested that the amount of the judgment should be released by an agreed order with the remaining balance held until these remaining issues could be resolved. But Ms. Helton she wanted to wait and resolve everything at once. So our position is we shouldn't be paying interest on a judgment when the judgment could have been paid, but we didn't have the opportunity to pay it because the funds are held pursuant to the court order.
Mr. Turley?
Ms. Locke is mostly correct that the funds remained held. I agree with her that she had proposed at one time that we do a partial distribution. And I explained at the time that I didn't agree. This wasn't my client's decision, it was mine. Part of the reason being attorney's fees is an issue before the court, and that would have required me to do additional work, which would have just further exacerbated the problem that we perceived to have existed. So, and then I will also observe that this hearing is approximately 2 months later due to no fault of my client or mine. I'm not saying it's anybody's fault, but we weren't the ones who requested the continuance. So our position is interest accrues by law. It's mandatory. It's not discretionary. The statute's very clear on that. And so that one's simple, though. I think you've heard everybody's pitch on that issue.
All right. The court's prepared to rule on the interest issue. A combined judgment was entered of record on November 22nd of 2024. It will be the court's ruling regarding what interest can be enforced against the fund. We'll start at 11/22 of 2024 on a judgment amount of $29,438.70. Interest will terminate as of the date the money was actually deposited into Mr. Turley's trust account. What date was that, Mr. Turley?
I don't have that answer at my fingertips, but Ms. Locke and I can figure that out.
All right. At that point, Mr. Kirkpatrick had essentially paid what he owed. He didn't physically turn it over, perhaps, but at that point, the funds that belonged to him were under the control of Mr. Turley's office, and the court deems that to be the appropriate date to terminate the computation of interest.
Now the debate over interest begins, and it's immediately clear this isn't just about numbers. It's about control and principle. Counsel spar over whether interest should accrue while funds sit in the attorney's trust account. One side insists interest is mandatory. The other claims it's unfair. The judge navigates the legal tangle, eventually deciding that interest stops the moment the funds were deposited, cementing a procedural win while highlighting the high-stakes tension behind seemingly dry calculations.
I don't really know what we're talking there. Several $100s, perhaps.
Yes.
I also will note that Mr. Kirkpatrick has been, for the most part, complying with the court's order regarding how he was to purge himself from contempt. He made appropriate $1,200 payments in November, December, January, skipped February for some reason, but then made payments in both March and April. Now, $200 of that each month is to be credited toward arrears, is it not?
Yes, and that will be included in the calculation, Judge.
All right.
And Your Honor, as a brief update, when Mr. Kirkpatrick and I were discussing before the hearing today, we both noticed the February payment. He made that payment this morning, and I sent the confirmation to Mr. Turley. So he is fully caught up on any arrears.
Well, okay. He made the February payment in April. All right. So what he did is he doubled up in April
Correct.
to make up for the payment he missed.
Yes.
All right. Well, I appreciate those efforts, truly. All right. So, Mr. Turley, is it a fair statement then the remaining issue is what, if any, attorney fees that should be allowed to your client for having to pursue her prior motion?
That's correct.
All right. And let's clarify for the record what amount you're currently seeking.
Attention shifts to compliance, with the court meticulously tracking every payment made or missed. Mr. Kirkpatrick had a February slip, but doubled up in April to make it right. It's a delicate dance, showing he's not fully blameless, but also setting the stage for the next big issue, attorney fees. This section gives us clarity on the factual backbone of the case and underscores how small missteps in court orders can spiral into major disputes.
So, Judge, this is outlined in our Exhibit 6, starting at page 26 of the materials. And that's our motion. And then the next exhibit after that is my affidavit regarding my client's costs and attorney's fees. Attached to that affidavit is a billing summary with all of the entries and charges. I went through it, initialed each page, and signed that document. And then after totaling everything up, we're asking for $11,406.
Let me make sure I understand. You're wanting Caleb to pay for your attorney fees in pursuing relief on behalf of your client, not related to contempt?
That's correct.
And why is that fair?
So at the trial, Your Honor will recall, basically all of the facts were related to things that Mr. Kirkpatrick either had not done in violation of a court order, those things being the contemptuous behavior, and also those things he did or didn't do that negatively affected the minor child. So these parties had come up with a parenting plan, and the evidence at trial was that there were serious concerns about drinking that Your Honor even noted yourself. And so our position is Mr. Kirkpatrick caused all of this litigation through his poor decision-making and at times contemptuous behavior. So we think that as a matter of justice and equity, my client should be entitled to her attorney's fees on everything. And as I noted in the affidavit, she was charged a significantly reduced rate as compared to my current customary rate.
All right. Ms. Locke, your client's response to this request for attorney fees?
Your Honor, we would ask the court deny the attorney's fees. Related to the parenting time, the court reduced my client's parenting time. Related to the other contempts, and the only spots where the court actually found my client guilty of contempt were the failure to pay the spousal maintenance and the child support. The court then entered a purge order, essentially, which said the contempt would be purged if you complied with paying $1,000 a month in support and paying an additional $200 a month. My client has done that. He's been compliant with the court's purge order. So that should purge his contempt. There should be no additional award of attorney's fees related to that. Additionally, there's some case law cited by Mr. Turley, and one of those is the financial needs and the ability to pay of my client. Well, as the court just noted, Miss Helton has had the opportunity to take at least almost $30,000 worth of cash that's sitting in her attorney's trust fund, a judgment that was awarded to her. But she elected not to. So we would question whether there truly is a financial need. These funds have been sitting there for 4 months now that she could have accessed, and we would have entered an agreed order for. So our position is that at this point, the award of attorney's fees is not just inequitable, it is truly a punitive sanction, and it's not reasonable and it's not appropriate.
Any reply argument, Mr. Turley?
Yes, Judge, and there's just a couple things I'd like to touch on in addition to what I said earlier in response to Your Honor's question. So Ms. Locke correctly notes that in our motion, we've cited some law for the proposition that the court can and often does award attorney's fees in a contempt situation. So as to the contempt piece of this, I don't even think that's a close call. Mr. Kirkpatrick was under a court order. He disobeyed it willfully, as Your Honor found. And importantly, in this case, this was not a situation where Brianna charged into court on some technical violation or something like that. She waited a very long time for Mr. Kirkpatrick to become compliant, or gave him the opportunity to become compliant. And as I recall at trial, there were text messages and other things of that nature entered into evidence that showed her informal efforts to get what she was due from the agreed upon judgment. Mr. Kirkpatrick ignored those requests. She had to pay her lawyer. And so if she's not awarded attorney's fees on the contempt issue, it effectively deflates the agreed upon judgment that she contracted for and she had to enforce through the contempt motion in the first place. So as a matter of justice and equity, we think that part of it should be an easy call for the court. In all candor, Judge, as Your Honor already alluded to, the closer call in my estimation is whether Brianna should be awarded any attorney's fees on the custody and parenting time issues that were tried to the court. And there's two reasons that we think that the court should award attorney's fees there as well. One is the disparity in financial positions. I cited for the court the Dunn decision in our motion. And as Your Honor, I'm sure already knows, the Dunn decision stands for the proposition that when evaluating a request for attorney's fees, the court has to consider need and ability to pay as it would in a spousal maintenance dispute. And that's effectively what Dunn did, was expand or translate the spousal maintenance analysis to the attorney fee analysis. And so the district courts in Kansas award attorney's fees often just for that reason alone. When one party has superior earning ability and superior financial position, it is, as a matter of fairness, the party in the inferior position will be awarded their fees oftentimes just to make things fair and right. The second reason is the reason I already explained to Your Honor. My client would not have filed that motion that was ultimately granted in part by Your Honor had Mr. Kirkpatrick not made bad decisions for himself and for the child. And so is it, as a matter of fairness, is it fair that Brianna would have to spend money to protect the party's daughter because of Mr. Kirkpatrick's bad decision-making? We think that given those two things, an award of attorney's fees across the board is appropriate, fair, just, and equitable. Finally, so that's the fairness piece of this, Your Honor. The other piece of this is reasonableness. In Kansas, typically when a court rules on attorney's fees, it's a two-step analysis. Step one is whether the fee is reasonable at the outset, and two is whether it's fair under the circumstances. As to reasonableness, I would submit that my affidavit makes it quite clear that the fee is reasonable in this case. Again, Ms. Helton was charged something far below my customary rate at the moment for reasons explained in the affidavit. And the total cost was around $11,000. And so for a case taken to trial with judgment entered with only one attorney involved for much of the proceedings, I think that's eminently reasonable under the circumstances. So Brianna is indeed asking for the full $11,000 and change. But if the court is not inclined to grant full relief on that question, we would at least ask for something like $7,500 or $7,000.
The attorney fee showdown explodes into full view. Tully methodically argues that his client shouldn't pay for delays caused by contemptuous behavior, while Locke fires back, calling the request punitive given that funds were already available. The courtroom tension is palpable. Fairness, financial disparity, and parenting issues collide in a strategic clash of legal minds. Every word counts, and you can feel the simmering frustration on both sides as they battle over who should bear the financial brunt.
Unless Your Honor has any questions, that's all I have to say.
My question for you, Mr. Turley, would be to follow up on Ms. Locke's valid point. Your client has accessible to her over $34,000, which is sitting or has been in your client trust account. Why shouldn't the court consider her resources and her ability to pay your attorney fees, since she's the one that has initiated litigation, and have her pay her own lawyer?
So with regard to Ms. Locke's argument that somehow Brianna's decision not to release the money early should be weighed against her, if Your Honor is asking about that, I can respond to that specific.
No, I'm not.
Okay.
I understand her reasons for that.
Okay. So as to the general question, Your Honor asks specifically, she's got this cash, why doesn't she just use it to pay you? Well, she's going to. Like, I'm going to get paid one way or the other, whether it comes out of Brianna's dollars or Mr. Kirkpatrick's dollars. I would just observe, Judge, that especially as to the contempt, that's completely unfair to my client. He just didn't follow court orders. My client tried to get him to multiple times, as Your Honor saw at trial, and he disregarded those requests. So if she's not awarded her attorney's fees on the contempt in particular, what the court is effectively doing is reducing the court order, the child support even. That negatively impacts the child in this case, if the court were not going to award attorney's fees on the contempt. And in all seriousness, Judge, I don't I don't think I've ever encountered a situation in my years of practice where attorney's fees are not awarded on a contempt of this kind. So, I mean, as to that issue, the court's decision is not whether to award her attorney's fees because she has money. The court's decision really is at base, do I penalize her because he didn't follow the court orders? And I just don't think that's fair.
Currently, I'm first intrigued about how you are able to determine so readily what's an easy decision for the court and what is a more difficult one. But with that said, the court at this time does feel that justice, fairness, and equity requires that Mr. Kirkpatrick be responsible for some measure of accountability and reimbursement of attorney fees in relation to the contempt action that was filed in this case. After all, it was necessary for Brianna and her attorney to conference with each other. In other words, some sort of interview process. Mr. Turley's office had to research the non-payment items. He had to do drafting of his motion. He had to appear in court to argue the case and then present that case and afterward draft an order stemming from those proceedings, which led to the documentation of the finding in contempt. However, the court is going to limit the attorney fee award to the matters which dealt with contempt. After all, while Brianna received some relief from the court in regards to the remainder of her motion, she did not prevail on 100% of the issues. The court deems it appropriate then to limit an attorney fee reimbursement to what this court believes is a reasonable amount for Mr. Turley's involvement in the narrow issue of contempt that was presented to the court. The court is going to allow 10 hours. And Mr. Turley, you are an experienced attorney, that you're able to charge a fair amount in conjunction with a contract with your client. The court's not going to interfere with that. But what the court's going to do, since you're wanting Mr. Kirkpatrick to pay for your fees, there's no contract between you and him. If you're wanting him to help subsidize your attorney fee bills, the court's going to utilize an amount which, after some research and thought, the court determines to be an appropriate average amount for attorney fees in this locality. And the court determines that to be a rate of $292 an hour. So the court will allow 10 hours at $292 an hour for the amount of $2,920 to be paid from Mr. Kirkpatrick's share of the fund that's being held by Mr. Turley's office. Any remaining amounts is between the attorney and the client.
The court delivers a decisive but measured ruling. Attorney fees are limited strictly to contempt-related WAC, 10 hours at $292 per hour, totaling $2,920. Tully gets a partial win, but the court draws a clear boundary between compensation and excess. This moment crystallizes accountability. The court acknowledges misconduct, enforces responsibility, and simultaneously prevents overreach. It's a classic example of judicial precision, fair, and strategically calibrated.
All right, with that attorney fee issue determined, Mr. Turley, what else does the court need to address today?
I think that's it, Judge. I do not begrudge the humor and sarcasm, but as to the title of this document, I'm open to suggestions.
Well, I noticed that you said this was a motion for attorney fee determination. Journal entry or order of attorney fee determination. And whatever other matters might be covered.
Okay.
And determination of interest. It would make it clear then to any scanner of the documents in this file that this is the order which deals with those issues. That's all I'm stating.
Okay.
All right. Thank you, though. I appreciate your request for clarification from the court. All right, Ms. Locke. Is there anything else from your perspective that we need to address here?
The only piece is the KPC overpayment, which was in line 5, I think, of paragraph 7, that Mr. Kirkpatrick will in fact get credit for all of the $200 additional payments that he made.
I think Mr. Turley had already pledged that he would make those adjustments. Am I correct, Mr. Turley?
Yes, those numbers just need to be updated through April. I agree.
All right,
No additional questions, Your Honor. Thank you.
very well. Then if there's nothing further at this time, the Kirkpatrick matter will currently be in recess and the meeting may be ended for all at this time.
Thank you.
In the final stretch, the court wraps up loose ends, document titles clarified, overpayments credited, and all parties confirmed on the next steps. The hearing concludes with a clean recess, leaving the contempt and attorney fee issues neatly resolved, but the tension lingers in the room. It's a masterclass in procedural closure, ensuring fairness while keeping the narrative tight. Make sure to like the video, subscribe to the channel, and we'll see you in the next one.